The question for the panel would be whether there had been a breach of good faith, for example, in not being willing to address the commitments, the joint commitments on alternative arrangements, and if so, there would be an exit as a consequence.
But the joint committee isn't a unilateral exit, because the joint committee is joint between us and the European Union. So it would need permission of the European Union to leave unilaterally. Therefore, it's not unilateral.
It's a joint body, but sits independently, yes.
Yes, but therefore, this has been advertised as a unilateral ability. It's not unilateral.
No,
it goes straight back into the withdrawal agreement. And whether it's under Article 20, which requires the agreement of the Joint Committee, which is the agreement of the EU, which is back to square one, that we can't leave without the EU agreeing.
No.
Well, how is it not?
Because what this says is, again, part of the political debate has been that the UK will be trapped in a backstop. It has no right of ending this, terminating this, disapplying it, whatever phrase. So what is clear here is that, if I take you to a specific line, could ultimately lead to disapplication of the obligations. So the point is there is scope to disapply. The mechanism, you're quite right, through doing that would be through the dispute resolution mechanism within the withdrawal agreement, whether that is Part 6 or Title 3 or through Article 20. But the point is that there is scope to disapply the obligations of the protocol, and that is what the United Kingdom...
But there's always been scope to disapply the obligations of the protocol if, under Article 20, the objectives had been met. This is advertised as a unilateral. I'm focusing on the word unilateral. This is not something the UK can do on its own. It needs, under Article 20, the approval of the Joint Committee, which is a joint committee between the UK and the EU. So we can't leave it without the permission of the EU under Article 20. Is that correct?
So I think there's two things being confused
well,
here.
Let's just focus on that.
Well,
and then we'll come to Title 3 of Section 6.
So what is unilateral is what we're asserting is our interpretation.
Okay.
And the fact, and this comes back to Richard's point, the fact that that is not disputed by the EU becomes common ground that goes before the arbitrator. So this is not saying that it's a unilateral exit in that regard, in the regard you're referring to. What it is saying is the ability to trigger, and our interpretation is what the Unilateral Declaration is referring to.
So that's very helpful. Thank you, Secretary State. What you are saying is that we have made a declaration saying that under the treaty we can ask to leave the backstop. But that's been blindingly obvious to anybody since the withdrawal agreement was produced. Of course we can ask to leave, but the ability to ask is not the same as the ability to leave, is it?
Well, what this is setting out is that the UK's position, which is it would be entitled to take measures to disapply the provisions of a protocol in accordance with the withdrawal agreement, and that is what it is setting out.
But the only measures it can take under the Unilateral Declaration is to ask permission of the EU to leave, because it's either on the Joint Committee or at the Arbitration Panel. But crucially, with the Arbitration Panel, because we're covering Articles 167 to 181, is Article 174. Because the Arbitration Panel is subject to interpretations of EU law as laid down by the European Court of Justice. And we, in the Unilateral Declaration, are accepting that the only way to get out is with the approval of a arbitration panel that is subject to EU law in matters.
No, with respect, Jacob, what you said is the only way to get out is with the approval of the EU. That is not correct. What this is saying is that the trigger, so what we're asserting here, in essence, is the trigger that we would apply in order to start. Now, where I agree with you is the process through doing so is through the mechanism that is set in the withdrawal agreement. But it is about what is the trigger. Now, I come back to where much of the debate has been, and in particular in the meaningful vote, was around the UK being trapped in a backstop where the EU was acting in bad faith, and not just the fact that that would have an indefinite nature, but also it would have a distorting impact on the negotiations themselves, that the UK almost would be required to concede aspects within the negotiation because, in essence, it had no right of access. And what the Unilateral Declaration is asserting is how we would trigger that mechanism.
But it doesn't mean that mechanism would work. But that's absolutely no change from what was there before. The Unilateral Declaration
because it's
doesn't add anything, because it simply says we could ask to leave the backstop. But we've always been able to ask to leave the backstop. That's not, in any sense, an improvement or a development.
I don't accept that interpretation. Now, we'll have a longer session with the AG and his statement. But I think also in a sense, I mean, I said earlier that this is both a question of legal interpretation and political interpretation. The starting point for this is that neither side wants to go into the backstop. There are safeguards to prevent it. What has been negotiated is legal commitments through the alternative arrangements responding to the concerns of Brexiteers in the House around avoiding the need to trigger that. And what the Unilateral Declaration does is then give further weight to the circumstances through which we could trigger, and I'm sure the attorney will set out further comments on that. But what's slightly lost in all of this is actually there's a huge amount in the deal which we're not getting into, because we're into sort of quite a narrow point of legal interpretation between two of us who no longer practice law.
I've never practiced law.
Even.
Thank you. The chair wants to move on, but thank you very much.